You're looking at attorney Kenneth Chesebro taking a plea deal ahead of his trial in the election interference case against former President Trump in Georgia. Chesebro, who was set to go on trial in just a matter of days, the plea deal comes just a day after his co-defendant, former Trump attorney Sidney Powell, agreed to plead guilty to 6 misdemeanor counts. I want to bring in senior investigative reporter Aaron Katersky for more. Aaron, what do you make of the timing here? Chesebro pleading guilty a day after Sidney Powell did the same.
And as potential jurors were being brought into that courtroom to start filling out questionnaires, because both Chesebro and Powell, as part of their defense tactics, requested an expedited trial, and the judge severed their cases from that of the others, and that meant that their trial was about to start next week, potentially.
At some point, the lies stop being rhetorical and start leaving fingerprints. That moment arrived quietly, not with sirens or spectacle, but in fluorescent-lit courtrooms where former Trump lawyers stood, raised their right hands, and said the unthinkable out loud. They didn't hedge, they didn't posture, they didn't argue theory. They admitted crimes, not abstract mistakes, crimes. Conduct they now concede crossed from advocacy into illegality. And they did it under oath, with judges watching, prosecutors listening, and the public record absorbing every word like wet concrete. This is not a media narrative. This is not spin. This is not interpretation. This is sworn testimony from the legal architects of Donald Trump's attempt to reverse the 2020 election, acknowledging that the plan they helped execute was not merely aggressive, not merely controversial, but criminal. Strip away the noise and look at what actually happened. 3 lawyers who operated at the heart of Trump's post-election effort, Jenna Ellis, Sidney Powell, and Kenneth Chesebro, each walked into Georgia courtrooms and pleaded guilty. Not all to the same charges, not all with the same admissions, but all to crimes tied directly to the scheme to invalidate legitimate votes and subvert the lawful transfer of power. Jenna Ellis admitted she knowingly or recklessly spread false claims about election fraud, not rumors, not opinions. False statements presented as fact, pushed to the public and to lawmakers, despite a lack of evidence and despite repeated court rejections. She acknowledged that she helped circulate lies about dead voters, illegal ballots, and fabricated fraud numbers in Georgia. She admitted that these claims were made with reckless disregard for the truth, a legal standard that collapses the defense of innocent mistake. Sidney Powell went further into the machinery. Her admission wasn't confined to speech. It reached into action. She pleaded guilty to conspiring to interfere with election duties by participating in the breach of voting systems in Coffee County, Georgia. That breach wasn't theoretical. It involved unauthorized access to election equipment, copying sensitive data, and compromising infrastructure under the pretense of uncovering fraud that did not exist. This wasn't rhetoric. This was intrusion. Kenneth Chesebro, the legal mind behind the fake elector scheme, admitted to felony conduct tied to the creation and submission of fraudulent electoral certificates. This was the plan designed to give Vice President Mike Pence a pretext to reject legitimate electoral votes on January 6th. The scheme that relied on confusion, delay, and constitutional distortion. The scheme that sought to replace lawful electors with forged alternatives. Chesebro admitted that elements of that plan were criminal. These were not low-level operatives. These were lawyers, Trump's lawyers, people entrusted with interpreting the law, not breaking it, people whose job was to keep their client within legal bounds, not escort him across them. And they didn't confess because of a sudden attack of conscience. They confessed because prosecutors had them cornered. Evidence, documents, communications, exposure. They faced the full weight of Georgia's racketeering statute, a law designed to dismantle coordinated criminal enterprises. Faced with the prospect of prison, they chose survival, probation instead of incarceration, reduced charges instead of life-altering convictions, cooperation instead of defiance. That context matters, but it does not diminish the admissions. If anything, it sharpens them. People do not plead guilty to felonies and misdemeanors involving election interference unless the alternative is worse. These admissions are not symbolic. They are strategic acknowledgments of reality, a recognition that the state could prove criminal conduct beyond a reasonable doubt. And here is the point that detonates Trump's core defense. Donald Trump continues to insist that everything done on his behalf was lawful, that the election was stolen, that the prosecutions are witch hunts, that he is the victim of partisan persecution, that no crime occurred. But the people who executed his strategy are now saying in court that crimes did occur, that claims were false, that conduct was illegal. That is not a minor contradiction. that is structural collapse. The "we did nothing wrong" defense depends on plausible deniability, on the idea that lawyers advised legality, that actions were within bounds, that mistakes were honest. That defense cannot coexist with sworn admissions from those same lawyers that the actions were criminal. Jurors don't need to be legal scholars to understand that contradiction. They only need to recognize that when the architects of a plan admit the plan was illegal, the claim of innocence at the top becomes radioactive. This is where pattern recognition matters. Authoritarian movements rarely begin with tanks in the streets. They begin with lawyers, with memos, with procedural manipulation, with technical arguments designed to launder illegality through complexity. History is littered with examples of regimes that attempted to seize or retain power by weaponizing legal ambiguity. The goal is always the same: create enough confusion to delay accountability, exhaust institutions, and normalize the abnormal. The fake elector scheme was not an improvisation. It was a calculated attempt to exploit constitutional processes. It relied on forged documents, coordinated messaging, and pressure on officials to accept an alternate reality. It assumed that if enough people played along, the system would break under its own rules. That is why Chesebro's admission matters so profoundly. He wasn't just a participant, he was a theorist. He wrote the memos, he outlined the strategy. He tried to construct a legal facade around an illegal objective. His guilty plea punctures the myth that this was all a good-faith constitutional dispute. It confirms that the plan's authors now recognize it as criminal. Ellis's admission matters because it demolishes the information warfare defense. The claim that Trump's team simply believed fraud existed collapses when a senior legal advisor admits to spreading claims with reckless disregard for their truth. Recklessness is not belief. It is indifference. It is the decision to push a narrative without caring whether it is accurate, because the narrative itself is the weapon. Powell's plea matters because it shows the transition from narrative to sabotage. When rhetoric failed, the operation moved toward physical systems. Breaching voting equipment is not speech. It is interference. It is the point where conspiracy leaves the screen and touches infrastructure. Taken together, these pleas map the escalation: lie, pressure, forge, intrude, delay, overwhelm. This is the authoritarian playbook rendered in legal filings. Now, here is where the forensic analysis becomes unavoidable. These guilty pleas do not legally convict Donald Trump. That distinction matters. Trump was not a party to these plea agreements. He has not admitted guilt. He has pleaded not guilty. The law does not permit guilt by association. But the law does recognize conspiracy. It recognizes racketeering. It recognizes coordinated schemes. And it recognizes the power of insider testimony. Cooperating witnesses are not peripheral. They are the backbone of complex prosecutions. Especially in cases involving organized activity, prosecutors rely on participants who can explain intent, structure, and direction. Documents show what happened. Witnesses explain why. Ellis can testify about internal discussions, about who directed messaging, about whether Trump was told claims were false. Powell can testify about who authorized the Coffee County breach, who coordinated access, who funded operations. Chesebro can testify about the development of the fake elector plan, who approved it, and how it was intended to be used on January 6th. These are not hypotheticals. These are the questions prosecutors ask when building conspiracy cases. And the Georgia case is not a symbolic indictment. It is a racketeering prosecution. That means the state does not need to prove that Trump personally committed every act. It needs to prove that he participated in, directed, or benefited from a coordinated criminal enterprise. This is where Trump's public posture becomes a liability. He has not distanced himself from the conduct. He has not repudiated the lies. He has not acknowledged wrongdoing by his lawyers. He continues to assert that the election was stolen and that the actions taken were justified. That insistence may play well with his base, but it collides head-on with the evidentiary record. Jurors are instructed to assess credibility. They are told to weigh testimony. They are allowed to consider whether a defendant's narrative is consistent with the facts. When multiple insiders testify under oath that crimes occurred and the defendant insists nothing illegal happened, the jury is forced to decide who is lying. And this pattern is not new. Michael Cohen pleaded guilty and testified that Trump directed the hush money scheme. That testimony helped secure Trump's conviction in New York on 34 felony counts. Alan Weisselberg pleaded guilty in the Trump Organization case and provided prosecutors with internal knowledge. Time and again, people from Trump's inner circle have followed the same trajectory: charged, confronted with evidence, pleading guilty, cooperating. This is not coincidence. It is gravity. The legal system exerts pressure. Those closest to the conduct feel it first. Some resist, some crack. Those who crack leave records, and records accumulate. The difference now is scale. The Georgia case is not about a single transaction or a single lie. It is about an attempt to nullify millions of votes. It is about an effort to override the constitutional mechanism for choosing a president. That elevates the stakes from corruption to democratic survival. And yet, accountability remains uncertain. Procedural delays, immunity claims, jurisdictional fights, political interference. Trump's return to the presidency has frozen federal prosecutions. The Supreme Court's immunity rulings have reshaped the landscape. The Georgia case faces appeals and challenges that could stretch for years. This is the danger zone for democratic systems. When evidence exists but consequences are delayed, normalization sets in. The extraordinary becomes familiar. The criminal becomes partisan. The public grows numb. That numbness is the objective. Authoritarian movements do not require everyone to believe the lie. They require enough people to stop caring whether it is true. They thrive in exhaustion, in confusion, in the fog created by endless delay and procedural obstruction. Trump's response to these guilty pleas reflects that strategy. He dismisses them. He minimizes them. He treats them as irrelevant personal choices by individuals acting independently. He does not adjust his narrative. He does not explain why his lawyers are admitting crimes if nothing illegal occurred. He simply repeats the denial. This is not a legal defense. It is a psychological one. It relies on the assumption that repetition can outlast evidence, that loyalty can outmuscle logic, that identity can override fact. But courts do not operate on vibes. They operate on testimony, documents, and corroboration. And cooperating witnesses change the calculus. They provide connective tissue. They turn fragments into stories. They allow juries to see the architecture of a scheme rather than isolated acts. This is why these pleas matter, even if Trump is never convicted. They establish a historical record. They document in sworn statements that the attempt to overturn the 2020 election involved criminal conduct by those closest to the president. They refute the claim that this was merely a contested election or an aggressive legal strategy. They show intent, recklessness, and action. They also send a signal. Future officials, future lawyers, future operatives are watching. They are seeing that participation in anti-democratic schemes carries risk, that the shield of power does not extend indefinitely, that when the pressure arrives, loyalty evaporates. That is how deterrence works, not through speeches, but through consequences. The tragedy is that those consequences remain incomplete. Donald Trump has not been forced to answer these admissions in a courtroom. He has not been confronted with his former lawyer's confessions under cross-examination. He has not been required to reconcile his narrative with their testimony. The system has not yet delivered resolution, and that unresolved state is itself corrosive. Democracy does not collapse all at once. It erodes through exceptions, through delays, through the normalization of behavior that would have been unthinkable a generation ago, through the idea that some people are simply too powerful to be held accountable. The guilty pleas of Trump's lawyers crack that illusion. They do not shatter it, but they fracture it. They show that the law still exists. That evidence still matters. That truth can still surface, even if justice lags behind. The question now is whether the public will absorb what these admissions mean, or whether they will be dismissed as noise in an endless cycle of outrage. Because here is the reality. When lawyers admit to crimes tied to election interference and the central figure refuses to acknowledge any wrongdoing, the danger is not confined to the past. It is predictive. It tells you what will happen next time. It tells you how power will be used if constraints disappear. This is not about settling scores. It is about recognizing patterns before they harden into precedent. The admissions are real. The conduct is documented. The threat is not hypothetical. If you care about understanding where this is heading, if you want to see these warning signs before they're buried under distraction and denial, stay engaged, pay attention, follow the evidence as it develops, because missing the details is how democratic collapse disguises itself as noise.